we're not strong enough, but I ain't never giving up. Gonna leave this future behind me. Na 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 na. I'll keep going, nothing can stop me. Na 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 na.
Yeah, I've called this the golden age of fraud, and you know, I teach a course on the history of financial market fraud, and one of the themes of the course is that the fraud cycle is a lag of the financial and business cycle. That the longer the business and financial cycle goes on, the more people's sense of disbelief erodes, and they begin to believe things that are too good to be true. I think that and when the bubbles burst, that's when basically, since most frauds need new capital, they're generally variations of Ponzi schemes. When people ask for their money back, that's when the fraudulent business models come to light. I've joked that the best defense attorney and the harshest prosecutor for these types of frauds is stock prices. When everything's going up, there's no incentive, no complaints, except for maybe some short sellers who are, you know, sitting there throwing stones. But generally, there's no political will to go after corporate wrongdoing. And it isn't until the public starts losing money in a big way that the mood changes. And since a lot of these types of prosecutions end up being political, when the public starts losing money, and institutions start, you know, saying, "Why do we own this? What's this accounting again?" That's when you tend to see the regulators and lawmakers and law enforcement begin to get active, and I think this cycle will be no different.
Well, hello everyone, and welcome to another extra. I know Wednesday was. I'm gonna check my audio levels because last time that was a problem.
The regulators and lawmakers.
Whoops. Before I do that, I should probably switch to the headphones in case I want to listen to audio and stuff without. No one said this was a professional outfit here. Well, hello everyone, and welcome. Okay, that sounded pretty good on that end. Like not necessarily the greatest levels, but not obnoxiously loud. Tonight I kind of wanted to get to something that popped up on my radar when I was looking at, you know, I tend to keep up with these lawsuits as I'm going along the week because, you know, I have nothing better to do with my evenings sometimes other than play, you know, War Thunder and read filings on Pacer. I'm a very interesting person, trust me. But I know some of this legal stuff, which I like to get to, and, you know, some of our viewers have watched, you know, follow for that. And some people also try and tune in for, you know, the meme stock stuff. Some people tune in for the, you know, financial information, things like that. But this is one of the things that kind of interests me and comes up a lot. And also, it's the Logan Paul CryptoZoo stuff. And I thought it was interesting, especially with this motion to dismiss, because that's going to be the main topic for tonight. We're going to be diving into that. But before we get to that, there's a few things that I want to kind of knock out because I don't want to deal with them Saturday. And maybe there'll be some meme stock stuff. Maybe there'll be some fun other stuff that we can do in there to make this a little bit more fun. But I kind of want to go into depth on the Logan Paul stuff because I don't want to just throw it into the Saturday show and just kind of speed run through it and then no one really gets anything. Also, I thought it was appropriate since I got the Coffeezilla Crime is Legal t-shirt to break it out. I had it on Wednesday night and then never, you know, kind of brought it up. So if you were watching Wednesday, you knew it was already here. But I thought it was appropriate to break it out for tonight as far as that's concerned. So let's kind of get some of this stuff out of the way, and then we'll go into the Coffeezilla lawsuit stuff. The first one is one that I meant to go over actually Wednesday, but then I was listening to meme stock crazies in their space talk about like the FINRA motion to quash, and we got, you know, 3 sheets to the wind yelling at idiots. So I didn't quite get to this one. I mean, it's pretty standard. I think it was on the list of things to go over for the Saturday show. But again, like I said, we kind of skipped over it because like some of the stuff we don't get to. But this was just a status update for the court. There are two Haktua lawsuits, and they are combining them. Which is not surprising. I mean, just, judicial efficiency, and also that way you don't get two wildly different outcomes or things like that. So consolidating these cases makes sense. And the plaintiff, I think they're represented by the same law firm in both cases even, which is, interesting. Usually that doesn't happen. The undersigned counsel represents the plaintiffs in this action. Plaintiffs reached out to counsel for defendant Alexander Larson Schultz regarding the status report, but have not received a response yet, so they're just going to go ahead and file this anyway. Counsel for defendant Schultz answered the complaint on May 21st. On July 28th, plaintiffs filed a motion to consolidate the two related cases. They're also trying to serve the foreign defendants, but haven't quite gotten there yet. The defendant, Tua the Moon Foundation, was registered in the Cayman Islands, while Clinton So and Over Here Limited were believed to be located in Hong Kong. On Wednesday, August 6th, process server informed us that service cannot be effectuated on Clinton So and Over Here Limited. We anticipate learning more information about why service could not be effectuated. And that's kind of where that case is right now. They're still trying to serve some of the defendants, but they have a class action and consolidated, are getting ready to consolidate those two lawsuits. Cool. The other one was the pump fund lawsuit. I don't have it up right now, but let me see if I have it on my list of things here. I know I've got a bunch of like the meme stock, like the MMTLP cases, because there's like 40 bazillion of them. But and the Willis v. Aaron. Yeah, we'll get to that in a second before we get into like the eating or the fun stuff. On that one, when it comes to the pump fund ones, I believe one of them is kind of in limbo right now. I haven't seen anything happen on that since June. And then the other one, they're trying to serve some of the defendants. I think they moved the court for alternative service because they couldn't do standard service. So I assume they're going to try and serve them by like email or their social media accounts or some form of way they think they can serve them, because they can't get regular service via the mail or some sort of process server. So that should be interesting. We'll see if the court grants it. The last thing before we go into the Holland v. CryptoZoo case is we have Willis v. Aaron. This has been the appellate court shenanigans from hell. If you recall from previous episodes, Nelson Willis is a soft-sit idiot who was sending a bunch of anti-Semitic and threatening emails to CEO of AMC Entertainment, Adam Aaron. Adam Aaron filed for a restraining order in Texas State Court. I think it was Harris County. I can't remember what the state circuit court was that it was filed into. Adam Aaron was told that he could not file via affidavit. He had to actually appear in person. They got ready to schedule a date for him to appear in person. In the meantime, Willis sent interrogatories and a subpoena request to the AMC Investor Relations. I know I should know it, but I don't know it off the top of my head who that guy was. And he, I think they said they served him, though it wasn't clear. After that happened, which either Adam Aaron got the subpoena aside, or just like, I don't want to, have to appear in court in front of my stalker who sends me threatening emails, decided to back out of the lawsuit. Not particularly surprising. So they non-suited the case, which under any law, a plaintiff can non-suit their own case up to the date of trial. Once trial proceed, you have to get permission of the court to non-suit the case. But at any point up to the trial date, a plaintiff can non-suit their own case so long as there's not any cross complaints. So he non-suited the case. Nelson Willis had a big hissy fit, went up to Texas federal court in the, I think it was the Eastern District, if I remember correctly, but I don't feel like pulling it up, or maybe I will pull it up. There it is, Nelson Willis, Eastern District of Texas. Hey, I was right. He sued there. What happened was he lost because, I mean, the case was non-suited. You have no claims for any of the stuff you want. So he appealed up to the 5th District, and we've been going on this carousel. Well, the 5th District finally got done with that stuff and told him to cheese off. The motion for reconsideration was denied. We're done with Nelson Willis for now. And so what basically goes from here is we go back down to the Eastern District Court because Adam Aaron filed cross-complaint claims and reapplied for that restraining order. So Nelson Willis will be back in the Eastern District of Texas Court on Adam Aaron's restraining order. He says he's going to appeal to the Supreme Court. And, you know, God bless his soul that he thinks he's going to get certiorari out of the United States Supreme Court. That is hilarious. You know, best of luck to you. I sincerely hope you succeed for the lulz. But I doubt you are going to find 4 justices of the Supreme Court that will give a shit about your petty meme stock nonsense. I'd be interested in seeing him try and make arguments in front of the Supreme Court. It would be wildly hilarious, but it ain't happening. Ain't happening. All right. So, to get you up to speed on the Holland v. CryptoZoo stuff, I'm sure most people know about what is going on, why we're here. If you follow Coffeezilla, who did the investigative reporting on this whole CryptoZoo stuff, he's currently being sued for defamation by Logan Paul over that. We will get to that. Because both these cases are kind of heavily intertwined because they go over the same sort of stuff. Last we left off was all the way back in April when we got some extra supplemental stuff from Logan Paul basically saying, hey, because of the new SEC ruling that meme coins are not considered securities, they're just considered a joke, bro. It was, you know, we didn't mean to steal all your money. It was just a prank, bro. It was just a prank. That's basically SEC policy now. If you say out loud that it was just a prank, bro, it's not securities fraud. that is how the SEC is handling it. If you run a cryptocurrency and you just say it was a prank, bro, you can't get sued. So that was the last supplemental on his motion to dismiss we heard. Some of the other plaintiffs got their motion to dismiss granted by the magistrate. The move for default judgment on Logan Paul's cross claims against the other defendants. See, that's what's silly about this case. So you got a plaintiff that's suing all these defendants, and then you've got Logan Paul suing the other defendants on cross claims. His motion for default judgment on those cross claims was denied. He has filed, as you can see there on the 5th, an objection to the report and recommendations on those. So we'll see how that goes. Basically, what that how all of that works is usually with these civil cases, you have a magistrate judge that hears over them because there are so many cases. You would be surprised. Oh, I don't think you should be surprised, but you might be. How many cases there are in civil court, especially on the state level and probably equally so on the federal level. So they go to a magistrate judge first, and they still have all the powers of a judge, except they're not like, I don't want to say that they're not a full judge. They're a judge. They're just a magistrate judge. So they give what's their report and recommendations, same as, like, say, a special master would. And then you can object to that report and recommendations, and then it is looked over by an actual circuit judge who then decides yay or nay on their agreement with the report and recommendations. So we will be seeing probably some argument back on that, and then we will get an opinion from the district court judge. In the meantime, we got the report and recommendations on the amended complaint, and that's what we're going to talk about tonight. Because this is, when I first read this, I was like, say what? This is bad. This could be potentially very bad for Coffeezilla. But I think the title kind of gives away where we're going with this. So we do know that the court recommends that defendant Paul's motion to dismiss be granted. We'll get into why and what the court said about that, because I think that's very important into analyzing this, because I don't think it's nearly as bad as it sounds. I don't think we need to really spend too much time on the background. If you want to go over the background of this, you can read the umpteen thousand YouTube videos there are on the failure that was the CryptoZoo project. So let's get into the discussion. Before analyzing the substantive aspects of this case, the court addresses a procedural issue, although neither party addressed it in its briefing. Defendant Paul filed a pre-motion answer on the original complaint. Rule 12b-6 requires that a motion for failure to state a claim must be made before an answer is submitted. In other words, a Rule 12b-6 motion filed after an answer is technically untimely. However, the Fifth Circuit has crafted an exception to accommodate such circumstances. Untimely Rule 12b-6 motions to dismiss are treated as 12c motions for judgment on the pleadings, also known as summary judgment, based on a failure to state a claim on which relief may be granted. So in other words, I'm not going to spend a whole lot of time on this one. The court doesn't. It spends like a page and a half. But basically, if you have, technically under Federal Rules of Civil Procedure, if you file for a motion to dismiss for failure to state a claim, technically, once you filed your answer, it's untimely. But the Fifth Circuit basically has this loophole that if you're filing it for failure to state a claim, and only that on the motion to dismiss, you can treat it as a summary judgment or judgment on the merits, failure to state a claim. And for that one, if you file it untimely, it's okay. So since this one is based on failure to state a claim, even though Logan Paul filed his answer to the claims already, it is not untimely for him to file this motion to dismiss under Fifth Circuit precedent. Moving right along. Applicable substantive law. Much to the court's frustration, plaintiff provides no briefing on the applicable law in this case. While the court appreciates defendant Paul at least pays lip service to the applicable law and ultimately decides to focus on Texas and California law, plaintiff neglects the issue entirely. Whoops. In the absence of guidance, the court clarifies the applicable law. Reason we need to do this is we're dealing with multiple jurisdictions here because of this class action and people being from multiple classes. So the court is basically, okay, what law is applicable and what do we need to do I had it right on the tip of my tongue and I started rambling and I completely forgot. Diversity jurisdiction, I assume. What laws are going to be applicable here and how are we going to have to analyze this case? Without spending too much time on this, because they go on for quite a long time on it and it's not really the big meat of what needs to be discussed here, they basically go with Texas law because where is it here? Yeah. Here, as mentioned, plaintiffs are silent on the issue. However, their response almost exclusively cites Texas law and courts in the Fifth Circuit, nearly all applying to Texas law for their common law claims. Meanwhile, defendant Paul briefly addresses the issue, addresses the issue's complexity in his motion, ultimately opting to focus on Texas and California law. The majority of defendant Paul's cases apply Texas law, but he seems to address California law out of caution, given that 2 of the 3 co-lead plaintiffs reside there. Likewise, the majority of the case in defendants Paul's reply apply Texas law. Based on the parties' briefing, it is abundantly clear they are not opposed to the application of Texas law. Basically, because of precedent, if you basically are filing in Texas, and even though there's multiple laws that could be applicable, multiple states' laws that could be applicable, because this class action has injured parties. Even in this case, injured parties from different countries. If you decide that you're going to make it as a plaintiff about, and all your citation is from this law, and the defendant's doing the same thing, you've pretty much agreed that the laws of this state is what you want the court to consider. And that's basically what the court has said here. Since the plaintiff and the defendant are both, saying Texas law is what we're replying to, that we're putting in our filings for consideration, that's what the court's going to use. We're not going to consider all this other states that could possibly, have laws that are applicable, since both parties have pretty much agreed to their own accord that we're going with Texas law. Texas law is what we're going to go with. So that gets us to the real meat and bones of this entire thing. So, defendant Paul, so shotgun pleading and group pleading. We've gone over this a bit on the old channel before it got canned. Group and shotgun pleading, you can't just group people for ease of purpose. You need to actually use, like, this person did this, this person did this, this person did this. Just because you have multiple defendants doesn't mean you can just list a whole bunch of claims and then just shotgun fire them all at everybody. You have to say, this defendant did this defendant did this, that defendant did that. So that's what we're going to do here. Paul raises 2 overarching qualms with the complaint. First, he argues plaintiff incorporation of each count into the next, or shotgun pleading, is improper cause and a cause for dismissal. Second, he takes issue with plaintiff's employment of group pleading or collective attribution of conduct to defendants or founder defendants. For these reasons, according to defendant Paul, the complaint does not comply with Rule 8A2. The court addresses each in turn. Defendant Paul argues, in committing the sin of shotgun pleading, the complaint does not pass Rule 8A2's muster. Defendant Paul believes the complaint violates Rule 8A2 by incorporating each count into the next, and then in the final paragraph, adding every paragraph in the complaint is hereby incorporated into every other paragraph. The rule provides a pleading must contain a short and plain statement of the claims, showing that the pleader is entitled to relief. A shotgun or group pleading is a complaint that violates either Federal Rules of Civil Procedure 8A2 or Rule 10B, both. A shotgun pleading is one that sets forth an excessive number of facts and then inserts in a conclusory faction that each of these facts supports a number of legal claims, with the result that each count is replete with factual allegations that could not plausibly be material to that specific count, and that any allegations that are material are buried beneath innumerable pages of rambling irrelevancies. However, to require plaintiffs to recount the specific facts upon which each claim rests when stating a claim would require plaintiffs to repeat several pages of facts with respect to each claim, and would render a pleading unwieldy and would distract from rather than add to its clarity. Yeah, if I've already given the whole facts of the situation and explained my entire pleading, and then have to go back over that again in each of the counts that I'm charging someone with, that creates redundancy and just confuses the situation. So there is a rule, but there are also exceptions to the rule. Defendant Paul next argues it says, okay, sorry, I skipped a part there that was important here. Although plaintiff incorporates some paragraphs into others, they do not include extraneous or excessive facts, and the court is able to gather which facts pertain to which counts. Accordingly, the complaint does not run afoul of the general bar against shotgun pleading. Defendant Paul next argues plaintiff's engagement in impermissible group pleading calls for the complaint's dismissal in its entirety. Although the complaint refers to defendant Paul by name 72 times, many allegations attributed to defendants are attributed to defendants collectively without specifying which defendant is responsible for the allegedly reprehensible conduct. It is true the Fifth Circuit does not look kindly on group pleading. Citing Noble. Defendant Paul argues the deficiency alone warrants dismissal and cites Noble Capital Texas Real Estate Income Fund in support of his assertion. But Noble is distinguishable. In Noble, the group pleading was more egregious, and at least one person named as defendant was not mentioned after the second page of the complaint. Whereas Logan Paul was named continuously throughout the complaint. Here, as mentioned, Logan Paul is named 72 times throughout the complaint, and the Fifth Circuit's disdain for group pleading is not absolute, nor does the group pleading always call for dismissal. Although the amended complaint does not always specify which defendant performed which action, it does not engage in impermissible group pleading, creating a category of multiple defendants into a clearly defined term does not in and of itself warrant dismissal. The court finds plaintiff's attribution conduct to defendant Paul with sufficient specificity, so dismissal based solely on the complaint's collective attribution is not warranted. And so the bell does not toll for plaintiff based on these shortcomings alone. Now, whether the court is willing to pierce the corporate veil to impute conduct to defendant Paul, or whether the complaint's fraud allegations meet Rule 9b's heightened pleading requirements are a different issue entirely. The court will address them below. So, plaintiffs have made it over first hurdle. The shotgun pleading argument did not stand, but the next hurdle is the piercing the corporate veil, which is the next step that the court will analyze. And then, of course, there's also the Rule 9b heightened pleading standards. Since this is a fraud case, as we've seen from all of the meme stock stuff, we have to deal with the slura and the heightened pleading standards that come with that. You have to give the specificity of who did what, where, and how. And you have to be specific on which defendants did what, and all that stuff. That's all stuff that we're used to, I think, here from previous episodes of Princess of Mount Stupid and previous episodes of Truth Be Told, because I mean this comes up a lot. Right? When you're covering lawsuits, even for trashy, shitty meme stocks, SLURA still applies, or the Private Securities Litigation Act. I'm pretty sure I got that right. Oh, we got someone watching on Rumble. What do you know? As broached above, plaintiff's complaint is replete with allegations attributed to defendants and founder defendants, referring to all named defendants except for defendant Bentov. As a short precautionary measure, plaintiff includes the following in their complaint. In the event parties are misnamed, basically a disclaimer. If they're misnamed, oopsies, our bad, we intended to use those, and there might be some that are excluded accidentally. Please, the acts or omissions by defendant included, but are not limited to the acts that we're claiming them of. So basically, disclaimer, we may not have included everyone, but everyone here participated in this. The court understands these paragraphs to mean that plaintiff wants the court to attribute the allegedly unlawful conduct to defendant Paul, even in those instances where he is not identified by name. Although defendant Paul does not, at least in his motion, explicitly address the issues of liability based on alter ego, piercing the corporate veil, or a principal-agent relationship, he does mention, as mentioned, take issue with the way the complaint lumps the defendants together. In a similar vein, as his group pleading objection, defendant Paul argues some of the plaintiff's allegations are misdirected, as he, unlike CryptoZoo, is not in privity of contract with plaintiffs or personally responsible for CryptoZoo's acts. To this, plaintiff reiterates that CryptoZoo was merely a vehicle to created to perpetrate a fraud as an alter ego for defendant Paul. So those are the two arguments right here. Basically, Logan Paul's like, the CryptoZoo is a corporate entity, is separate from me. You can't sue me for doing these acts that the company did. And basically, plaintiff is, well, like the company is your company, and you created it to perpetrate this fraud. So, from what the court could gather, plaintiff seems to request that defendant Paul be held vicariously, liable to 6 of their 8 common law claims: breach of express contract, breach of implied contract, unjust enrichment, negligence, conspiracy to commit fraud, and civil aiding and abetting. In his reply, defendant Paul cautions the court against wasting its time with plaintiff's half-hearted conclusory mentions of veil piercing in their complaint. The court here addresses whether it should pierce CryptoZoo's corporate veil for the purposes of imposing liability on defendant Paul. Generally speaking, a corporate officer acts as a corporation on a corporation's behalf are deemed to be acts of the corporation. I own a company, I do things for the company, or say the company has shareholders and I'm made CEO. I don't do them as me, I do them on behalf of the company as an employee of the company or the owner of the company. They're not necessarily me, the entity, doing them, and that's why we're having the discussion of piercing the corporate veil, because the argument plaintiffs are making is this company was built and made by Logan Paul to defraud people. So he's hiding behind the entity known as CryptoZoo in order to defraud people. The person orchestrating this is Logan Paul, is their argument. So we need to pierce through CryptoZoo, the corporate entity, and go after the person who is committing the fraud, Logan Paul. That is their argument. However, Texas has long had 2 methods for holding an individual corporate agents or officers personally liable when they are acting within the course or scope of their employment and the role of corporate agents: piercing the corporate veil or direct individual liability. Plaintiff only mentions liability based on the principal-agent relationship and proportion of the complaint cited above. Because plaintiff provides no indication of this argument pertains to defendant Paul, and because neither plaintiff nor defendant Paul mentions it in their argument again in their briefing, the court limits its analysis to liability based on alter ego and veil piercing theories, even though there were probably other legal theories they could have used. That's footnote 8. Footnote 9. Under Texas's choice of law rules, whether a corporation, LLC, or individual may be held liable pursuant to the veil-piercing theory is determined by the law of the state in which the entity organized. CryptoZoo is a Delaware corporation, so the court would normally apply Delaware law to the veil piercing analysis. However, as mentioned in previous sections, the parties only briefed the court on Texas law. The court here applies Texas law, but regardless, the outcome would not differ under Delaware law. Well, that's good to know. That's a very interesting note, footnote 9 there. But yeah, basically, both of them just went straight up and assumed that, you know, they'd be dealing with Texas law because they filed in Texas, but like because of the diversity of the members of the class and even the lead plaintiffs of the class, you could have made arguments that California law was applicable. And even here, the court is basically saying that for the purposes of, you know, piercing the corporate veil and other things like that, or choices of law for, you know, dealing with that veil piercing or determining which state law would be applicable. I mean, the company was formulated in Delaware, so they could have said, well, under Texas law, Delaware law would be applicable here because the company's organized in Delaware. But as the court says, not that that would make much difference because, you know, if you were here for the original channel when we were talking about, you know, Delaware law for the AMC litigation, when it comes to like securities and corporate liability and stuff like that, Delaware is kind of the master class in everybody. That the smart kid. Well, yeah, I mean, depends on your opinion if they're the smart kid in class. But never mind the fact the rest of the students copy their homework anyway. In other words, it's not necessary to pierce the corporate veil where a plaintiff alleges a defendant is personally liable for his tortious conduct, because piercing the corporate veil is a form of vicarious liability called for only when a plaintiff seeks to hold an officer liable for the actions of a corporation. Generally, piercing the corporate veil is not a separate cause of action, but a method to impose personal liability on shareholders and corporate officers who would otherwise be shielded for liability or corporate debts. Thus, in an action seeking to hold an agent individually liable for his tortious or fraudulent acts, the corporate veil is not required to be pierced. Notably, the law is well settled that a corporate agent can be held individually liable for fraudulent statements or knowing misrepresentations, even when they're made in the capacity of a representative for the corporation. Accordingly, insofar as plaintiffs allege defendant Paul personally engaged in tortious conduct, the court need not pierce CryptoZoo's veil in order to hold him liable for his alleged torts. So basically, there you go. As far as the court analyzes it, I don't know why that word was so hard to reach for, but basically the way the court analyzes it is, you know, if as plaintiffs argue it, Logan Paul said things that were knowing misrepresentations or were knowingly fraudulent, then they don't need to pierce the corporate veil. Logan Paul said them on behalf of the company. You can still hold him liable under those tort claims. Delaware Public where's this footnote? Oh, that's from this up here. Oh, whoopsies. I hate when that happens, when you get footnotes that wrap around like that. Why can't we push this? Where's that footnote, though? Oh, because footnote 9 is like right here. So you get a footnote that wraps around. That's annoying. Delaware publicly disfavors, so that's back all the way up there in 9. Well, we're rolled past that. This is all up on Court Listener, so if you do want to follow along, why don't I drop that into the chat? You can go to Court Listener and look up this case. You can even look it up by the case number up. Well, not this part, but like this part right here, the like center part. 1:23 CV. You'll want to make sure you get in the 2 zeros and then 110, or look it up as by the case caption, which is Holland v. CryptoZoo, up on Court Listener, and it'll be the most recent filing, I'm pretty sure. Yeah, because it was filed today. So really awesome that court listener is a thing, because like Pacer is annoying. Pacer gets really expensive once you get going along, and being able to basically crowdsource court documents is nice. Really, really helpful. So if you do have Pacer, please do contribute. I don't want to be the only one buying these documents. In fact, this one I actually had. I bought it because I really wanted to see it. So here we go. Whether a plaintiff may pierce an entity's veil depends on whether the plaintiff's claims sound in tort or contract. As we previously mentioned, if it's tort, you don't need to pierce the corporate veil. They said them. But if it's based on contract, then you will need to pierce the corporate veil. I'm pretty sure this is where we're at. Whereas a tort claim may freely pierce the veil, a contract claimant may only pierce the veil if defendant has also committed an actual fraud against the plaintiff for the defendant's direct personal benefit. See, yep, there we go. So if it's a contract dispute and the corporate entity broke the contract, you have to prove that in order to pierce the corporate veil, you have to prove that the defendant intentionally had the company break the contract for their own personal benefit. Otherwise, it's just the company did it. You don't get to pierce the corporate veil. But if it's actual tort, like I'm setting up here and I'm running a company and I say that tomorrow, I'll make sure that that there'll be a discount and by this much, and I'll do all these things that are basically lies, and they never actually happen, then the tort is me. It's a tortious action. I made the willful misrepresentation. I told people things that they would get this money and these things and these things that I promised, but I never actually followed through on it. So you can hold me liable without piercing the corporate veil, even though I'm acting on behalf of the company. I'm the one who said the things that were tortious. This distinction exists because Texas Business Organization Section 21.223 has been held to preempt the common law in situations where a plaintiff seeks to pierce the corporate veil as to their contract and contract-related claims. As mentioned, plaintiff seeks to pierce CryptoZoo's veil based on claims sounding in both contract and tort. As such, the court categorizes its analysis accordingly, beginning with the statutory veil piercing in the contract context. Veil piercing as to pure contract claims. After a series of statutory amendments within the past few decades, Texas courts have collectively agreed upon Section 21.223's predominance in the realm of veil piercing for contract and contract-related claims. Texas law insulates a shareholder from a corporation's contractual or contractually related obligations on the basis that the holder is or was the alter ego of the corporation, or on the basis of actual or constructive fraud, a sham to perpetuate a fraud, or other similar theories. However, creates exemptions to the limitation. A shareholder may be held personally liable for a corporation's obligations if the obligee, I hate that word so much, demonstrates that the beneficial owner caused the corporation to be used for the purpose of perpetrating and did perpetrate an actual fraud on the obligee primarily for the direct personal benefit of the beneficial owner, which we already discussed. And so, to accept a corporate officer, to accept a corporate officer from the general shield, I think what he was going for is exempt. Regardless of avenue, a plaintiff must demonstrate the corporate officer perpetrated an actual fraud primarily for their personal benefit. In sum, to pierce CryptoZoo's veil to impose liability on defendant Paul as to plaintiff's contract and contract-related claims. Plaintiff must show defendant Paul committed an actual fraud for his own personal benefit. As for the first requirement, it bears mentioning, in the context of piercing the corporate veil, actual fraud is not equivalent to the tort of fraud. Indeed, the requirements for showing actual fraud are less burdensome than those for establishing fraud. Okay. The Fifth Circuit defined actual fraud as involving dishonesty for the purpose or intent of deceit. Courts may deduce fraudulent intent from all the facts and circumstances. I hope so. Here, in an effort to rebut plaintiff's breach of contract claims, both express and implied, defendant Paul highlighted each purchaser of CryptoZoo products agreed to CryptoZoo's terms and conditions. Okay. And CryptoZoo, not defendant Paul, was a party to the terms and conditions. I see where we're going. Thus, he cannot be held to have breached contracts to which he was not a party. But you owned the company, dude. But what? But you owned the company. No, what? Plaintiffs, on the other hand, believe that they have adequately alleged CryptoZoo was merely a vehicle to perpetuate the fraud as an alter ego for defendant Paul and other individual defendants. So the court would be justified in piercing adequately that whole thing there. So the court would be justified in piercing CryptoZoo's veil to impose liability on defendant Paul for CryptoZoo's breaches. The breach to which plaintiffs refer stems not from the representations in the terms and conditions, but from verbal contracts created by defendants, represented assurances that they would provide a functional game. It's not so much about the terms and conditions themselves. It's about the implied contract of, we are going to deliver a product. Here, we're going to deliver a product. Promise. Don't deliver the product, but take your money. That is the implied contract. The court is basically saying the terms and conditions don't matter here. Like, it's part of the contract, but the implicit contract is, we'll provide you a service that you were paying for. You never delivered the service. That's fraud, and it's a breach of the contract. Only to fall short on their end. The complaint points to a variety of statements defendant Paul personally made, including, the game was completed and tested in 2021. CryptoZoo is a really fun game that makes you money, and the project is backed by a massive team. But then, in 2024, defendant Paul came clean. The game never existed and would never be released. CryptoZoo would not make customers money, and the project was not backed by a massive team. The court believes in making the statements in 2021, knowing they were untrue, as evidenced by his 2024 alleged admissions, defendant Paul's purpose was dishonest, and he acted with the intent to deceive plaintiffs into purchasing CryptoZoo products. Accordingly, plaintiffs have adequately pled the first requirement of actual fraud. Going good so far, but we know this is getting dismissed, so where do we trip up here? It's coming up. And I'm pretty sure it has nothing to do with this stuff so far. As for the second requirement, the actual fraud be committed primarily for the officer's personal benefit, plaintiff provides nothing to support this inference. There you go. So, you need to prove, under contract law, to pierce the corporate veil, you need to prove that not only was it a fraudulent act, but it was done solely to benefit the defendant. The benefit derived from the actual fraud must be one that is direct and personal to the fraud. I assume what we're going for here is fraudster, but I can't make heads or tails of that. This requirement is met where the evidence shows that funds derived from the corporation's allegedly fraudulent conduct were pocketed by or diverted to the individual defendant. Here, plaintiff argues defendant Paul made various misrepresentations. Only defendant Ibanez, defendant Greenbaum, and potentially other defendants sold large amounts of digital products for immediate and large profits. Right. So you can pierce the corporate veil against them. They made off with the money, but you're going to need to establish more to suggest that Paul benefited. In other words, plaintiffs allege other defendants derived a direct and personal benefit as a result of defendant Paul's actual fraud. There is no indication he did. Having failed to meet the second requirement, the court declines to pierce the corporate veil to impose liability on defendant Paul as to plaintiff's purely contractual claims. Veil piercing as to tort claims. Having disposed of plaintiff's contractual claims, only the veil piercing theories as to their tort claims, unjust enrichment, negligence, conspiracy to commit fraud, and civil aiding and abetting remain. As mentioned, the protections of Section 21.223A2 applies not only to contract claims, but also any matter relating to or arising from the contractual obligation. That this language indicates the statute applies to claims holding a shareholder or owner liable for a contract-related corporate obligation, both contract and tort. As far as the court can tell, all four of the plaintiff's tort claims are contract-related, as a direct proximate result of defendants' intentional and unlawful taking of plaintiff's assets without providing the promised product or services. Plaintiffs have been deprived of the profits and other benefits of purchasing and investing in defendants' product. Defendants had a duty of care to reasonably meet and provide for the promised products and services. Plaintiffs are unaware of the falsity of the statements made of the defendants and in relation to on their accuracy, paid money to defendant based on such fraudulent statements. Plaintiffs, because of defendants aiding and abetting each other's fraud, unaware of the falsity of the statements made by defendants, relying on their accuracy, paid money to defendants based on such fraudulent statements. Plaintiffs' tort claims can be boiled down to this. Defendants work together in misrepresenting material facts about CryptoZoo to induce plaintiffs into entering into contracts and buying products from CryptoZoo. Thus, if these claims are in fact contract-related tort claims, as the court believes them to be, they necessarily suffer from the same ill-fated outcome as the pure contract veil piercing theories. Oof. Not good. To reiterate, the court finds it imperative to note the above veil-piercing analysis has no bearing on defendant Paul's personal tortious conduct. That is, if plaintiffs have properly alleged he personally committed torts, In a recent case, the Supreme Court of Texas put an end to the long unsettled debate. We hold that Section 21.223 does not apply to and thus does not limit liability for claims against corporate shareholders and officers premised on their alleged tortious conduct as agents of the company. In other words, the Keys Court does not understand Section 21.223 to shield a corporate agent who commits tortious conduct from direct liability merely because the officer or agent also possesses an ownership in the corporation. Thus, whether performed in his official capacity or otherwise, defendant Paul is to be held liable for his personal torts. Because neither party briefed the court on veil piercing under Section 21.223 to summarily dismiss plaintiff's attempts to pierce the corporate veil would be unnecessarily harsh. This is the good news. Accordingly, the court recommends plaintiffs be given leave to amend and identify what direct and personal benefit, if any, defendant Paul derived to justify piercing the corporate veil under Section 21.223. So that's our first step here. We know that this is not going to be dismissed with prejudice. In fact, the court has actively asked, hey, you missed this step. You missed this thing. Go fix it, especially given that the Supreme Court just recently ruled on it. Fix this thing, and we can get back to this discussion, which I think also opens up the fact that the court kind of believes the plaintiffs here, that they've at least made it past the motion to dismiss phase. It's not like Logan Paul is a particularly likable person. I don't think we have any problems there. So, like, yes, I think the court does believe that plaintiff has plausible claims. The problem is they didn't plead them very well, and they forgot to go over certain things that they need to do, and so the court doesn't want to punish them for that. And that's kind of where we're at there. Let me adjust this a little bit. There we go. Burp. Common law claims is where we get different. The court now turns to plaintiff's 8 common law claims: fraud, breach of contract, breach of express contract. Come on. What the heck? Did it just decide it wanted to lock up on me or something? Yes, it did. Come on. Can we stop that now, please? Thank you. Fraud, breach of express contract, breach of implied contract, unjust enrichment, negligence, fraudulent misrepresentation, conspiracy to commit fraud, and civil aiding and abetting fraud. Those are our 8 claims. Counts 1 through 6, fraud and fraudulent misrepresentations. Ooh, we get a nice footnote we probably should go over. For counts 1 through 6, plaintiffs assert claims of fraud and fraudulent misrepresentation. Texas law recognizes 2 forms of common law fraud: fraudulent misrepresentation and fraudulent inducement. I'm probably going to guess that fraudulent inducement is, well, I mean, both sound pretty applicable to me, but then again, I'm not a lawyer. Although unclear, the court assumes plaintiff intends to raise a fraudulent inducement claim. Okay, I was righter than I thought I was. Amazing. So that's what we're going to go with here, probably, or at least that's what the court's going to analyze. seems like a reasonable conclusion to make. In their complaint, plaintiffs argue defendant Paul made various affirmative misrepresentations to fraud them. As previously mentioned, those representations include CryptoZoo was complete and tested back in 2021. CryptoZoo is so fun and a really fun game that makes you money. Okay, it's going to lock up again. Awesome. All right, there we go. The project is backed by a massive team and funded by like $1 million. By like $1 million, guys. It's a big number. It sounds so dude, bro. By like $1 million. Okay, I'm gonna stop lingering on that. Later, when the public began to doubt his devotion to finalizing the game in May of 2022, defendant Paul stated he had never given up working on CryptoZoo daily, and again in January 2023 he promised to finish and deliver the game. Okay. Well, this PDF is really not having any of this. So we're going to stop trying to highlight things because apparently that makes it very angry. Plaintiffs have not alleged that they or anyone relied on the misrepresentations by defendant Paul. In essence, defendant Paul believes, depending on the statement, plaintiff's reliance was either non-existent or unreasonable. What? Defendant Paul also adds, to the extent that any plaintiff bases any claim or allegation or omission, they cannot prevail without pleading and then proving that defendant Paul owed them a duty to disclose. What? Okay, we got a footnote here. That's okay. And aside from the court, that should be helpful because I'm already confused by this argument. Although plaintiff did not expressly plead fraud by non-disclosure, a separate cause of action, hint, hint, the first count certainly reads as a fraud by non-disclosure claim. And defendant had a duty to tell customers, including plaintiff, that CryptoZoo would never be functional and that they had no intention of supporting the project or the CryptoZoo community. Normally, courts do not require that plaintiffs separately plead fraud by... Okay, non-disclosure is a separate claim. Considering the plaintiff fraud by non-disclosure claim, although not separately pled because fraud by non-disclosure is a subcategory of fraudulent misrepresentation. However, plaintiffs attribute no omission specifically to defendant Paul or explain why he owed a duty for that matter. So the court focuses its analysis on affirmative misrepresentation as opposed to concealment. Hint, hint on your amended complaint. Like the court, it feels like the court's like, yeah, Logan Paul is a dick, so I'm going to give you some helpful suggestions on your amended complaint when you get around to that, because there's some things here that are important. And I don't mean to, like, you know, do a drive-by and fire strays at attorney at Attorney Tom here, but like that seems to be what the court feels here is like, you know, maybe this isn't, you know, their legal expertise, but the court is sort of giving helpful suggestions here, it seems like, because there's a lot of elements it's pointing out as missing, and it is basically like we know from up here earlier that the court has said that they're going to give them leave to amend, that this is not going to be, you know, with prejudice. So that seems to be the angle here. Is like, you guys have got 90% of a case that works. Can you get me the rest of the 10% and we're Gucci? Plaintiff responded, Plaintiff responded arguing defendant Paul's mischaracterizes the burden to prove reliance. Under the fraud created the market doctrine, plaintiffs are entitled to a presumption of reliance, and even if that was not the case, plaintiffs believe they adequately alleged specific reliance as well. Defendant Paul, however, argues plaintiffs' dependence on the fraud created the market. Are we talking about fraud on the market? Not the fraud created the market doctrine is misplaced, at least as to the plaintiff's common law fraud claims, because it only applies to federal securities claims. Which is kind of true. The court focuses analysis primarily on the contested elements of the plaintiff's fraud claims, materiality, and reliance. Fraud claims are subject to heightened pleading requirements. In alleging fraud or mistake, a party must state with particularity the circumstances constituting the fraud or mistake, malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. At a minimum, Rule 9b requires that a plaintiff set forth the who, what, where, when, and how of the alleged fraud. Under Texas law, there are two types of common law fraud. Simple fraud, known as fraudulent misrepresentation, and fraudulent inducement, which is someone allegedly induces another to enter into a contract by using false representations. These are separate causes of action, but they share the same elements, which are defendant made a material misrepresentation that was false and was either known to be false when it was made or was asserted without knowledge of its truth, negligence. The defendant intended the representation to be acted upon, and it was relied upon, and it caused injury. The only distinction between the two claims is that, unlike fraudulent misrepresentation, fraudulent inducement is a particular species of fraud that arises out of the context of a contract and requires the existence of a contract as part of its proof. Ooh, boy. Regardless, this variance, critical to the survival of any fraud claim is materiality. A fact is material if it would likely affect the conduct of a reasonable person concerning the transaction in question. Generally, common law fraud it's all good, bro. Generally, common law fraud requires the misrepresentation be one of present fact as opposed to false promise to perform in the future. Oh boy. However, a promise of future performance constitutes an actual misrepresentation if the promise was made with no intention of performing at the time it was made. So, generally, if someone promises to do a thing in the future, not fraud, unless it was well established they had no intent of ever producing on the thing that they promised. Puffery, unlike a material misrepresentation, refers to an expression of opinion not made as a representation of fact. We have the greatest cars in all the United States. Our candy is the tastiest candy known to man. That's puffery. While a seller has some latitude in puffery, in puffing his goods, he is not authorized to misrepresent them or to assign them benefits or virtues they do not possess. Our cars have the highest safety rating. Do they? With respect to defendant Paul's statements, With respect to defendant Paul's statements, the undersigned is of the opinion some are mere puffery, while others are material misrepresentations. Defendant Paul's statements that CryptoZoo is so fun and a really fun game that makes you money are irreparably puffery. I don't know so much about the. I go along with the court that, yeah, it's fun. It's a really fun game. That it makes you money. I don't know if that's puffery. That sounds a lot like an actual like statement of fact, because it very much did not make any of the people involved money. Just saying. Albeit less obvious, defendant Paul's deception of the project as one backed by a massive team and funded by like millions of dollars also constitutes puffery. Non-actionable puffery comes in at least two plausible forms. One, an exaggerated, blustering, and boasting statement upon which no reasonable buyer would be justified in relying on, or a general claim of superiority over comparable products that is so vague that it can be understood as nothing more than a mere expression of opinion. What would be material, were it not so vague, would be the statements about the game's completion date. Plaintiff's exact wording is as follows. Ultimately, defendants never released the game, though allegedly it would be completed in early 2023, despite defendants' statements from 2021 that it had already been completed and tested. The first of these public statements was made during the public announcement of CryptoZoo in August 18th, 2021 by defendant Paul, the majority owner of CryptoZoo's online celebrity, via his YouTube show, Impulsive, claiming CryptoZoo game was so fun and really fun, that game that makes you money. This excerpt leaves the court with a host of questions. When did defendant say the game would be completed and tested? In 2021 or 2023? Who said it was completed? Did defendant Paul say the game was completed during the YouTube episode, or did he merely boast about how it is fun? While the court can certainly see how an affirmation falsely claiming the game was completed and functional by a certain date could be material, the court simply cannot draw the inference defendant Paul made that statement when plaintiff provided only fragments of facts accompanied by vague attributions to the conduct of defendants. What are material, on the other hand, are those statements where defendant Paul made assurances in 2022 and 2023 regarding his continued devotion and intent to finalize and deliver on the game. Assuming defendant Paul never intended to hold true to his promises, it is plausible that those statements, unlike the others, could induce a reasonable person to rely and act on them, making them material. But even those statements suffer from their own unique deficiencies, as described in greater detail below. Also, to a viable fraud claim is reliance. A plaintiff establishes reliance by showing the defendant's acts and representations induced him to either act or refrain from acting to his detriment. The court first addresses the only non-puffery initial promotional statement, namely that the game was completed in 2021 or 2023. The court seems highly confused about what they're trying to say there. That's a problem. Then defendant Paul's continued devotion statements. Evidence of reliance is often different for each individual depending on how and what each was told, what each knew of the matter, and how each reacted. Proving reliance in a class action suit is undeniably more arduous than an individual suit. Nevertheless, the Supreme Court of Texas has conclusively decided the burden on plaintiffs to prove reliance in order to recover on any of these theories, including fraud, is in no way altered by the assertions of claims on behalf of a class. Can I get the thing to highlight? Never mind. The meaning in Strongbone, the 20,000 class members were held to have the same standards of proof of reliance. There we go, finally. Meaning in Strongbone that the 2,000 class members were held to have the same standard of proof of reliance, for that matter, all of the other elements of their claims that they would be required to meet if each sued individually. Consequently, proof of reliance or lack of reliance necessarily requires an individualized determination, because under all the same facts and circumstances, one person may have relied on the misrepresentation in reaching a decision, while another did not rely on it in reaching the same decision. So is the court seriously suggesting that each individual class member needs to tell the court what induced them? Is that what we're getting at here? You can't have some general argument that encompasses all of the class members. You have to have each individual person's reason for inducement. Bravo on the logical consistency, I guess, but that seems a bit silly to me. I guess I get it, but it just that seems silly. Just a bit silly, especially in the context that they use for the cited case here, that you're going to tell me that if you need to prove inducement, you need to go to all 20,000 class members and go, what was your reason for being induced in this fraud? What was your reason for being induced in this fraud? And potentially have 20,000 different reasons? Okay, sure. I guess. No, the show's not going away, MJL. I'm just here for the night for this thing because I kind of wanted to go over the case more depth than we'll get into Saturday. Still having Saturday show too. This is ultimately where plaintiff's fraud claims fall short. Well, there we go. Assuming plaintiffs adequately attributed this statement, Defendant Paul publicly announced the game was completed and tested on his YouTube channel on August 18, 2021. The vast majority of plaintiffs purchased CryptoZoo products on or after that date. So presumably, most could have heard Defendant Paul's statement, believed in the availability of a finished product, and purchased accordingly. But plaintiff also alleged defendants misrepresented the status of the CryptoZoo game to entice Paul's loyal online fans and the public into investing into CryptoZoo products, and then failed to ever provide a functional CryptoZoo game to use said CryptoZoo products. Based on plaintiff's vague assertion alone, it is not clear which plaintiffs, if any, heard defendant Paul's initial promise statements, let alone acted in reliance on it. For this reason, plaintiff's indeterminate allegations of reliance on defendant Paul's initial promise statement runs afoul of Rule 9b. So yes, you must get how each person relied on that statement and why. Sounds silly, but that be the case law. Again, these are all mostly technical errors. Like, the court hasn't said that the underlying, like, actionability of the fraud is not necessarily, like, wrong. It's just you got to go through and plead all the elements and plead them with specificity. So if you could fix that, bro, we can get on with this. As to defendant Paul's continued devotion statements, plaintiff faces an even steeper obstacle. Defendant Paul stressed he made those statements on May 14th, 2022 and January 13th, 2023. But 139 out of 140 plaintiffs purchased CryptoZoo products prior to those. Oh, yeah, that's a good point. Had already purchased the products, so you can't be induced by something if you've already purchased it, my bro. I mean, it goes to the fact that he never intended to produce a product, but you can't be induced by something if you didn't purchase the thing. You've already been induced. So you need to fix that first statement and how people were induced by that first statement, and then maybe that could be a supporting fact, but you can't use the other two statements as inducement. All right, I get what the court's saying there. Thus, only Jamie Martinez, the sole plaintiff to purchase products after defendant Paul reiterated his continued devotion, could conceivably rely on them. The court agrees any allegation of reliance by the 139 other plaintiffs on defendant Paul's continued devotion statement present a temporal impossibility. And even Jamie Martinez's individual reliance claim suffers the same imprecision issues discussed above. Therefore, plaintiff's reliance on arguments as to defendant Paul's continued devotion statements necessarily fail. All in all, plaintiff's fraud claims do not meet the heightened pleading standards of Rule 9b. Defendant Paul raises a few other reliance-based arguments the court finds less availing. He argues even if plaintiffs had relied on his statements, their reliance is unreasonable. But Texas law does not require a plaintiff to show reasonableness of its reliance on a misrepresentation to prove fraud. Rather, Texas courts simply demand proof that the party acted in reliance upon a false representation. We're going to be fabulously wealthy and rich. Did you? And if not, and they relied on it, it doesn't matter how unreasonable your statement was. You made a promise. It didn't happen. Instead, the reliance need only be actual and justifiable. Further, he contended plaintiff's reliance, if existent, was unjustifiable given certain plaintiffs' own admissions that they possessed investment experience. Not so. To determine justifiability, courts inquire whether given the plaintiff's individual characteristics, abilities, and appreciation of facts and circumstances at or before the time of the alleged fraud, it is extremely unlikely that there is an actual reliance on the plaintiff's part. However, experience alone does not render reliance unjustifiable. The mere fact that Roberts was an expert regarding whatever does not preclude recovery for fraudulent misrepresentations. As a final note on the fraud claims, plaintiff urges the court to apply a more lenient standard to their common law fraud claims under the fraud on the market theory, which creates a presumption of reliance. We are familiar with the fraud on the market claim dealing with securities, but as the court's going to get here and say that these theories are only available for federal securities claims. That's why we're familiar with them here in meme stock land, lawsuitville things, because or even the Emoji Gate lawsuit, as Platinum likes to talk about. But yeah, so fraud on the market is only allowed in securities claims, not in general fraud claims. Federal courts have repeatedly have refused to apply the fraud on the market theory to state common law cases, despite its wide acceptance in federal securities fraud law context. And yet, given the potential, see here, this is the part here. The court basically says these claims are strong, you just need to plead them correctly. And yet, given the potential strength of plaintiffs' assertions, if adequately pled as to their fraud claims, the court believes they should be afforded the opportunity to amend. That, I expect that to be in the next freaking Coffeezilla filing in the defamation lawsuit. We just had a magistrate judge go over the motion to dismiss Coffeezilla. That whole sentence is going to be lifted. I can almost guarantee it. And yet, given the potential strength of plaintiffs' filings, like the court sees that these are just technical errors. The entire argument is not unreasonable that Logan Paul defrauded people. So the court's like, give it a second go, give me an amended complaint, and we'll move from there. If plaintiff can plead reliance with more specificity, that is, the who, what, where, when, and how, as to defendant Paul's fraudulent statements, they should be allowed to do so. Plaintiffs have constructed a skeletal framework of at least some claims, and the court is confident that there are numerous sources of information available sufficient to flesh out with specific details to meet the requirements of Rule 12b. Words matter, and if plaintiff did indeed rely on defendant Paul's statements to their detriment, he should be held accountable for his. Accordingly, the court recommends defendant Paul's motion to dismiss on counts 1 through 6, fraud and fraudulent misrepresentation, be granted. The court further recommends plaintiff be given leave to amend to cure the above identified deficiencies. Counts 2 through 3, breach of express contract and implied contract. Under Texas law, a valid contract exists if these 6 elements are present: an offer, acceptance, in strict compliance with the terms of the offer, meeting of the minds, a communication that each party consented to the terms of the contract, execution and delivery of the contract with intent it become mutual and binding on both parties, and consideration. A contract is expressed when its terms have been explicitly set out by the parties, whereas a contract is applied when its terms arise from the acts and conduct of the parties. In other words, the difference between contracts formed through express promises and those through implied promises is the means by which they are formed. The elements required to prove both are identical, but where an express contract's assent is expressly stated and an implied contract's assent must be inferred from circumstances of the transaction. For their breach of express contract claims, plaintiffs seemingly attempt to cobble together elements of both the terms and conditions as well as alleged verbal contracts stemming from defendants' representations to support the extent of a valid contract. In essence, plaintiffs jam together 2 pieces of different puzzles in a vain hope of producing a final coherent product. Unfortunately, the case law does not support this tactic. On this topic, the Supreme Court of Texas has authorized limited circumstances in which a plaintiff may combine 2 elements of 2 contracts to support a finding of 1 breach of contract claim. Jeez, I forgot this was 75 pages. I was just listening to it at work. No wonder we're going on for ages here. Plaintiff's claim for breach of contract and the TNC against defendant Paul fails as a matter of law because it is well established that a defendant cannot breach a contract to which he is not a party. Having left the corporate veil unpierced, defendant Paul is not a party to the terms and conditions, nor do plaintiffs explain how defendant's conduct constitutes a breach of the sole terms of the terms and conditions plaintiffs invoke. Defendant will strike to do the best for the product and the community. Regardless as to defendant Paul, plaintiff's allegations of breach of the terms and conditions is misdirected, and plaintiff's arguments for breach of express verbal contract do not fare much better. This claim appears to be a less than inconspicuous attempt at recasting their fraud claims. The valid and enforceable express contract that plaintiff entered with defendants includes defendants' representations that they would provide a functional version of CryptoZoo at the time of the Zoo tokens and CZ NFTs were publicly known. Generally, this method is also disfavored. See Century Prods Co. v. Costco, granting the plaintiff's motion for summary judgment as to the defendant's counterclaim for breach of contract, which was in fact a fraudulent inducement claim recast as a contract claim. Also fatal to plaintiff's breach of express verbal contract claim is the absence of proof of a valid contract. What was defendant Paul's offer? By what terms he and plaintiffs had a meeting of the minds? Neither plaintiff's complaint nor their response sheds light on these issues. Those defects prove no less fatal for plaintiff's breach of implied contract claims. To prevail on a breach of contract and implied in fact contract claim, the plaintiff must plead the existence of an invalid implied contract. Now, whether these elements simply were not pled or facts to support them do not exist, which are two completely different things, but having recommended leave to replead their corporate veil piercing theory, upon which the claim partially relies, the court does not believe it futile to afford the plaintiff another bite at the apple. In short, the court recommends that defendant Paul's motion as to plaintiff's breach of contract claims, both express and implied, be granted. The court further recommends plaintiff leave to amend. Count 4, unjust enrichment. One second here. Unjust enrichment. Primarily, the court notes under Texas law, it is not clear that unjust enrichment actually functions as an independent cause of action. Importantly, a cause of action for unjust enrichment requires proof that the defendant received a benefit and that retention of that benefit would be unjust. As the court already addressed the fraud claims deficiencies, and plaintiffs do not allege duress, that leaves them with only one available avenue of unjust enrichment by taking of an undue advantage. Here, plaintiffs argue defendants have been unjustly enriched by their wrongful receipt and retention of profits and other benefits they deprived plaintiffs. Presumably, plaintiffs refer to events on Zoo Day when defendant Paul, defendant Strobel, defendant Levin, defendant Ibanez, and defendant Greenbaum purchased CryptoZoo digital products at an artificially low value. Thereafter, only once the project was publicly announced, defendant Ibanez, Greenbaum, and potentially other defendants sold large amounts of the digital products for an immediate and large profit, effectively stealing the money of customers who had invested. This is what plaintiffs refer to as a rug pull, presumably substantiating their unjust enrichment claims. The court certainly sees how defendant Ibanez and Greenbaum obtained a benefit, but it struggles to see the same for defendant Paul. Yeah, that continues to be the problem here. There we go. I accidentally hit the back of the chair handle. Probably should add that in there. Yeah, so that continues to be the big problem here. You know, when Logan Paul says, well, I didn't rug pull anybody, I didn't take money out, it was the rest of them. It's a fatal problem here with unjust enrichment. Said differently, if only defendants Ibanez and Greenbaum participated in the alleged rug pull by selling off assets at a higher value and absconding with the funds, how did the events of Zoo Day confer a benefit to defendant Paul? Survival of this claim is contingent on plaintiffs' demonstration that the person sought to be charged had wrongfully secured a benefit or had passively received one which would have been unconscionable to retain. Absent disregard of the corporate form which the court already declined to do, plaintiffs were required to, but fell short of alleging individual benefit obtained by defendant Paul. Thus, the court cannot in good faith allow an unjust enrichment claim to proceed with no evidence of enrichment. Oof. In addition, defendant Paul seeks dismissal of plaintiff's unjust enrichment claim based on the Fifth Circuit's observation that certain equitable claims, such as this one, are inapplicable when the parties have an express contract governing the subject matter of the parties' dispute. Defendant Paul is correct, to an extent. True, the Fifth Circuit found an unjust enrichment theory of recovery could not lie when the contested issue was governed by a valid contract. But as delineated above, the court cannot ascertain under which contract, the terms and conditions, or an oral contract, plaintiff seeks recovery, let alone whether either of them govern the contested issue. Only once plaintiffs clarified the ambiguities in their contract claims can the court determine whether a contract does indeed control, and by exertion whether an unjust enrichment theory of recovery is available. Accordingly, the court recommends defendant Paul's motion as to the plaintiff's unjust enrichment claims be granted, and the court further recommends plaintiff leave to amend the above described deficiencies. We continue to run into this problem of lack of clarity on what's being charged. The good news is the court continues to be favorable. Yes, we have to grant Logan Paul's motion to dismiss, but we see where there's a potential case here. So fix it, and we can rediscuss. But they're the only time that you grant, the finality of it. The only times that you get to that. Clearly, what the court is going here is that it's hopeless. There's nothing that will make, you've offered your best claims, and there's nothing that can happen here. So that so long as that happens, at least I guess you can avoid the with prejudice part of this. But so far, continues to be a clean sweep, and it looks like it will be. I mean, we know that from the beginning, but so far, nothing here seems to suggest that this can't be fixed. Perfectly fixable things. And there's even points where the court has pretty much said, I can see a plausible claim here so far. You're just not quite there yet. Get there, please. Count 5, negligence. Plaintiff alleges various purportedly negligent acts and omissions, some directly attributed to defendant Paul and others only tangentially, those being he promoted a non-existent product or service. 2. He falsely represented CryptoZoo's functionality. 3. Failed to provide promises and products or services. 4. Manipulated the market for Zoo tokens and CZ NFTs and failed to support the CryptoZoo community. By virtue of his misleading statements, plaintiffs aver defendant Paul created a duty of care. Condensed, defendant Paul's motion raises 2 arguments. 1. Plaintiff failed to plead he owed plaintiffs a duty, and 2. Economic loss rule precludes recovery. The court agrees with both. Common law negligence requires proof that 1. The defendant owed a plaintiff a duty of care, 2. Defendant breached that duty, 3. The plaintiff suffered damages, and 4. The breach of duty proximately caused those damages. In the corporate context, without piercing the corporate veil, a corporate officer is only liable for the breach of a duty of care owed to third parties independent of the business's duty. It goes without saying the alleged independent duty must be apart from the employer's duty. At the very least, 2 of the 5 above negligent acts, failure to provide promised products or services and failure to support CryptoZoo community, are not only intimately tied to the CryptoZoo's duties, but are arguably CryptoZoo's duties exclusively. See, now that earlier we talked about you failed to pierce the corporate veil to get at Logan Paul, these acts, and especially like the negligence and the like duty to provide a product, these are corporate like these are duties of reliance from the corporate entity. And unless you can get to this whole thing was Logan Paul's, plan all along, twirly mustache, and that, the company, CryptoZoo, was just a shell for him to commit the acts that he was doing, then these duties are you can't pass them on to Logan Paul. They're duties of the company. And since, as we discussed earlier, they failed with the current complaint to pierce the corporate veil, then here we are. At the very least, 2 of the 5 above negligent acts, failure to provide promises community not only intimately tied, but are arguably duties of the company itself. Covered at length in the veil piercing section, the undersigned opines that even plaintiff's tort claims are contract related, but assuming the rest of plaintiff's negligence allegations are extra contractual, they do not survive. The remaining acts and omissions, i.e. promoting non-existent products or services, manipulating the market for CryptoZoo tokens, and falsely representing CryptoZoo's functionality, are more aptly characterized as negligent misrepresentation claims. The Supreme Court of Texas explained that regardless of any independent duty, negligent misrepresentation claims are viable only if a party sustains an injury independent from those stemming from the contractual breach. The court strains to see how plaintiffs' alleged contractual injuries differ from those here. Monetary loss as a result of CryptoZoo purchases. The economic loss rule is no less damaging to plaintiffs' negligence claims. The rule is typically one raised by defendants as a defense that bars negligence and certain other tort claims for recovery of economic losses when the loss is limited to the subject matter of a contract or to the product itself. The rule provides that there is no liability in tort for economic loss caused by negligence in the performance or negotiation of a contract between the parties. Failure to provide products or services under a contract falls squarely within the economic loss rule. Yeah, that makes sense. And plaintiffs do not seem to challenge that they purchased CryptoZoo products in accordance with the terms and conditions. No amount of additional facts or veil piercing can alter the reality. Plaintiff admits they purchased the products and services from CryptoZoo, not defendant Paul, pursuant to the terms and conditions. Put another way, by their own admissions, plaintiffs have foreclosed themselves negligence as an available means of recovery, at least at least is it at least as it relies to the assurances made in the terms and conditions. Thus, as a matter of law, plaintiffs are precluded from recovery for negligence based on the terms and conditions. However, plaintiffs also allege defendants were negligent in manipulating the Zoo token and CryptoZoo NFT market. Although arguably extra contractual, this argument dies on the vine. As a prerequisite to asserting a claim of negligence, there must be a violation of a duty imposed by law independent of any contract. Duty is the threshold inquiry in establishing negligence. If a plaintiff must allege and prove the existence and violation of a duty owed to him by the defendant to establish liability in tort. Furthermore, in general, the party claiming that a duty exists has the burden of establishing its existence. Based on plaintiff's conclusory allegations alone, the court is unable to ascertain what duty, if any, defendant Paul owed plaintiffs. Accordingly, the court recommends defendants Paul's motions as to plaintiff's negligence claims are granted, and plaintiff's negligence claims as to defendant Paul be dismissed with leave to amend only as to any alleged extra contractual breaches. So this is the first time that the court has actually said, yeah, some of this stuff, it's dead. The only negligent stuff you can do is things that are outside of the contract you made with the company when you purchased the project, purchased into the project, any of its products, anything like that. Because number one, you didn't pierce the corporate veil, and number two, even if you did, like, still, these are all things that arguably the company owes you. It's not stuff that Logan Paul owes you specifically. You signed the contract with the company. You're going to have to prove a little bit more to get there. We're getting there. 45 of 75. Counts 7 and 8. Conspiracy to commit fraud and civil aiding and abetting fraud. Preliminarily, the court notes, on account of the court's recommended dismissal of the underlying tort claims, these final two common law claims necessarily fail. The viability of both claims for conspiracy to commit fraud and civil aiding and abetting hinges on the existence of an underlying tort. Yeah, see, that's the problem that people kind of forget when it comes to conspiracy claims, or like say stuff like RICO or things like that. They're not claims in and of themselves. They attach to an existing claim. They, like, you can't, if I'm going to accuse someone of a conspiracy, it has to be a conspiracy to do something. A conspiracy like to commit murder, a conspiracy to rob, a conspiracy of, like, you can't make a claim of like conspiracy or RICO, racketeering, aiding and abetting, unless there is an actual claim to attach it to. Where were we? Here we are. Okay, so that's back to the citations. Even so, the court finds it prudent to resolve a contention among the parties, the intra-corporate conspiracy doctrine. Okay, that's interesting. Courts in this district have long observed that the intra-corporate conspiracy doctrine, it is a long-standing rule that in this circuit, that a corporation cannot conspire with itself any more than a private individual can. And it is the general rule that the acts of the agents are the acts of the corporation. I work at a Toys R Us, and I'm mislabeling prices for the purposes of defrauding people. Those are acts. That's not a good example. But yeah, I mean, that makes sense. If I'm an employee and I'm doing something at the direction of the company, that's what it sounds like they're trying to say, then like it can't be a conspiracy. Like all of it's done at the behest of the company. Yeah, it can't conspire with itself. So people acting within the company apparatus can't be a conspiracy. This is all stuff that's done under the apparatus of the company. So say my boss directs me to mislabel products or misprice them to make them look more make them look a different price to induce people to buy them, or produce fake advertisements or things like that. Like that's not a conspiracy. That's something that's being done by the company. It's not conspiring with itself. These are all employees of the company. It kind of gets back to the whole thing that like people miss with a corporation. A corporation is its own sort of like sovereign entity. People hired by it or acting within it are all the company. So like employees doing things on behalf of the company isn't a conspiracy. The company can't conspire with itself. Maybe hopefully that's a better explanation. Looking at the complaint, it is not at all apparent which specific defendant plaintiffs aim to implicate in the conspiracy or inculpate in the aiding and abetting. Rather than shed light on these ambiguities, plaintiffs attack defendant Paul's assertion of the intra-corporate conspiracy doctrine as a means of precluding their conspiracy claims. Courts, including the Fifth Circuit, have recognized that the intra-corporate conspiracy doctrine does not apply when the corporate employees act for their own personal purposes. So, I personally mislabel the price of products and pocket the difference for my own personal gain. It's not something the company is doing. It's something I am doing to enrich myself. The court agrees. Courts have fashioned an exception to the rule that a corporation cannot conspire with its employees. When the officers of a corporation act for their own personal purposes, they become independent actors who can conspire with the corporation. I'm the CEO of a company. I issue shares and say it's for a corporate purpose, and then I take the money from the share issuance. That is conspiring with the company to steal shareholders' money. Insofar as plaintiff alleges defendant Paul acted for his own personal purposes, he cannot be held to have conspired with CryptoZoo. This is, in a somewhat circular fashion, brings the court back to plaintiff's veil-piercing attempt. It seems to pierce CryptoZoo's veil and thereby bring a conspiracy claim. Plaintiff must prove defendant Paul acted for his personal benefit. Likewise, in order to independently prevail on a conspiracy claim against defendant Paul, a corporate officer, plaintiffs must also prove he acted for his own personal purposes. Circularity aside, it is abundantly clear plaintiffs must provide, but have not. Defendant Paul acted in furtherance of his own personal purposes to allege an actual conspiracy claim. Given the conspiracy claim's dependence on the viability of plaintiff's veil-piercing claims, as well as both the conspiracy and aiding and abetting claims, reliance on underlying fraud claims, for all of which the court recommended leave to amend, leave as to these claims is also proper. Accordingly, the court recommends that defendant Paul's motion be granted as to the plaintiff's civil conspiracy and aiding and abetting claims, and further recommends plaintiff be afforded leave to amend. Oh boy, counts 9 through 23 state law claims. No wonder that part's going to take 20 some odd pages. Give me just a second while I get a refill of water, because this seems like it'll take a while. Maybe some ice and stuff. So, like, so far, it seems very much like the court is like, you are so dangerously close to a case. Just tidy up this and we can move on. But so far, it's like you haven't properly pled the claims. So I can't really. I mean, I can tell you there's some things to fix, but you're not quite there yet. So now we get to the state law claims. So we've dealt with all the stuff that is applicable to federal law. So now we're left with the Texas state law claims, which again the court had some niggly bits about because the court felt that, you know, they could have done more as to what proper law should have been applicable here, because you have people who are in multiple states, multiple countries, let alone multiple states. There could have been different state laws that were applicable, but that's back further. They went with Texas law because the parties pretty much sound like that's what they were going to submit to. Plaintiffs raise a total of 15 state statutory violations in their complaint. Oh, so we got multiple state law claims here. Okay, this is where we get into the fun stuff. Oh boy. Every statute, yeah, because some of these plaintiffs are from different states, so different state laws are applicable. Welcome to diversity jurisdiction. Yay! What federal courts are made for. Every statute listed is some form of Consumer Protection Act prohibiting unfair trade and advertisement practices. Plaintiffs' 15 statutory violations, along with experts relevant to this analysis, are listed below. We're not going to read all those, so we're just going to briefly go over them. Arizona's Consumer Fraud Act, California's False Advertising Law, California Consumer Legal Remedies Act, California Unfair Competition Law. What? Colorado Consumer Protection Act, Florida Deceptive and Unfair Trade Practices Act, Iowa Private Right of Action for Consumer Frauds Act, Illinois Consumer Fraud and Deceptive Burden Practices Act, Massachusetts Business Practices for Consumer Protection Law, North Carolina Unfair and Deceptive Trade Practices Act, New Jersey Consumer Fraud Act, Nevada Deceptive Trade Practices Act, New York General Business Law, Pennsylvania Unfair Trade Practices, Texas Deceptive Trade Actions and Practices. Taken together, all 15 of plaintiffs' state statutory claims require a showing of reliance or causation, which many states are consider synonymous. Having already concluded plaintiff failed to allege either, yep, court need not delve into these claims any further for now. The court therefore recommends the defendant Paul's motion as to the claims be granted, plaintiff be given leave to amend, and the 15 statutory state claims. Count 24, violation of the Security Exchange Act. Oh, this is going to be the fun one. Remember when I talked earlier about how, because of how the Trump administration has changed the securities law as to meme tokens, that now, well, not change the law, but basically, I mean, the SEC, through the new SEC chair, has basically said, if you're a meme coin and you say, it was just a prank, bro, we didn't mean to defraud you, honest, pinky swear. Pinky swear we didn't mean to defraud you. Then, no, what? Go away. What? Then you don't, it's not a securities violation. It's a meme token. It's just a joke. It's just a joke. Just a prank, bro. What are you doing? Stop whatever you're doing. I don't like it. I'll just adjust things. Plaintiff's first federal statutory claim asserts a violation of Section 10B of the Exchange Act in conjunction with Rule 10b-5 promulgated under the Securities Exchange Commission. Their claim seems to be rooted in three of defendants' fraudulent acts: deceiving plaintiff with their false and misleading representations, artificially inflating the price of Zoo tokens and CryptoZoo NFTs prior to plaintiff's purchase, and causing plaintiffs to purchase worthless, unregistered securities. In rebuttal, defendant Paul puts forth two arguments. One, the SEA is inapplicable as to Zoo tokens and CryptoZoo NFTs are not securities because they do not qualify as investment contracts. Even if the SEA did apply, Securities Exchange Act did apply, plaintiff failed to plead this claim with the requisite particularity required under the Private Securities Litigation Reform Act of 1995, the SLRA, one of our favorites here on the channel. The court begins with the former, whether CryptoZoo transactions qualify as securities. The general purpose of the Securities Exchange Act is to regulate a wide variety of financial instruments that are termed securities. Needless to say, the existence of a security is a prerequisite to recover under the Securities Exchange Act. Thus, the threshold question here is whether the transactions at issue qualify as securities. Plaintiff's complaint consistently refers to Zoo tokens and CryptoZoo NFTs as unregistered securities. In the response, plaintiff clarifies the type of securities they believe CryptoZoo transactions to be: investment contracts. The statutory definition of a security includes, among other things, investment contracts. The court and the parties are in agreement that SEC v. W.J. Howley Company controls the determination of whether a transaction qualifies as an investment contract. Under Howey, an investment contract means a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the effect of the promoter or a third party. Courts interpreting Howey understand investment contracts to require three elements: an investment of money in a common enterprise with profits derived solely from the efforts of others. Ultimately, this test requires a case-by-case approach. Defendant Paul does not seem to dispute, nor has the complaint given the court reason to doubt the first two elements are present here. Rather, he takes issue with the third element. So qualification as an investment contract here hinges on the existence to which profits were derived solely from the efforts of others. Defendant Paul first argues no consumer who agreed to the terms and conditions can claim that defendant Paul led them to expect profits solely from his efforts. The reason being that the terms and conditions expressly disclaims CryptoZoo as an investment vehicle and admonishes against expectations of profits. Even though you said that, whatever. CryptoZoo products were created as art pieces intended for people to enjoy collecting, not as, that seems highly fucking irrelevant. Like, I can say that my art is creative, but if a market produces that, comes to be that, that's such a silly argument and such a childish argument of how whatever. And CryptoZoo makes absolutely no guarantees regarding the value of NFTs, aside from one that we strive to do for the best of the project community. The court finds this argument unavailing. Good, because I sure as fuck didn't find it availing either. As plaintiff points out, whether a transaction qualifies as a security or not is not defined by a defendant's label, but by the economic realities of the overall operation. Good. In essence, defendant Paul argues in favor of form over substance, despite various courts consistently denying that approach. When a court analyzes whether something is a security, the court will look at the substance over form. Therefore, the court will not consider express disclaimers in a contract when determining the character of a security. Yeah, that makes a lot of sense. Because if I can just say, like, again, trust me, bro, it's not a securities market. I say so. It's such a dumb argument. And it's also childish. Like, even if you intend for no market and one develops, like, and you profit from it, or others profit from that market that develops, like, does that change anything materially? And indeed, defendant Paul's selective amnesia. Well, the court does not like that argument at all. And indeed, defendant Paul's selective amnesia is convenient at best and self-serving at worst. Get him! Perhaps he does not recall publicly endorsing comments such as, if you sell, you lose, common invested knowledge, and he's probably saying, hey, I'm sick of you guys blaming your investment decisions on me. That said, the terms and conditions designation of CryptoZoo products as non-securities is not dispositive. Instead, the court looks to the economic reality and the totality of the circumstance to determine whether the transactions at issue qualify as investment contracts. Next, defendant Paul argues because there is a real likelihood of some plaintiffs purchase those items through secondary markets rather than directly from CryptoZoo, those purchases could not have reasonably relied on the managerial efforts of defendant to reap profits. Like, again, irrelevant. The products came to be from you. Presumably, defendant Paul's inspiration for this argument stems from plaintiff's division of the class into at large into 4 subclasses, 3 of which include plaintiffs who purchased some form of product directly from defendants, with the final class being those who purchase CryptoZoo products in the open market. Regardless, this argument too has been rejected time and again. You know, like, I don't have to purchase shares and securities directly from the company. In fact, the vast majority of shares are traded in the open market. It doesn't change the fact that the inducement of what you said about the company or the security in question, like, if I buy the security expecting, like say I buy a bond of a company expecting the company to pay me out, like it doesn't matter if I bought it from the company directly or Jane down the street, it's still your security product. The fact that the transaction in question occurred on the secondary market does not by itself prevent those transactions from involving investment contracts. Yeah. Although somewhat contradictory to their division of subclasses when listing each plaintiff by name and describing their representative purchases, every paragraph says each named plaintiff purchased CryptoZoo products from defendants. Thus, even if the issue of secondary market purchases were determinative, plaintiff seems to, albeit inconsistently, allege that they purchased the products directly from defendant, which is abundantly clear is at least 3 of the 4 of the classes of the plaintiffs purchased directly from the defendants. All this to say is whether CryptoZoo purchasers brought the products directly from CryptoZoo or in second hand, it is not itself conclusive of whether the purchasers expected profit from the efforts of CryptoZoo founders. Defendant Paul's final and most promising argument is on the topic. On this topic concerns the very nature of purchasing cryptocurrency. The volatility of the market, so the argument goes, forecloses any reasonable expectations of profits derived from defendants' efforts. In other words, defendants believe they sold plaintiffs a finished product as opposed to a dynamic investment vehicle whose productivity depended not on their efforts, but rather the ebb and flow of the crypto markets. Plaintiffs, meanwhile, contend defendants concerted efforts on to market CryptoZoo as a community, and their promotion of benefits tied to product ownership are indicative of the heavy hand defendants had in CryptoZoo's enterprise, and by extension, plaintiff's profits. While defendant Paul clings to Ripple in support of this argument, plaintiff urges the court to mirror the findings in Bolina. But the court believes Coinbase to be far more posit. In Coinbase, the defendant provided a platform and other services that allowed consumers to transact in hundreds of different crypto assets. In addition to providing a platform for transactions, the issuers and promoters of the crypto assets through the website, social media posts, others, repeatedly encouraged investors to purchase tokens by advertising the ways in which their technical and entrepreneurial efforts would be used to improve the value of the assets, and continue to do so long after they were made available trading on secondary markets. One particular crypto asset, the CHZ, allowed sports fans to acquire branded fan tokens from any team or organization, and accorded the holders of fan tokens various opportunities and interaction-based benefits. In making its determination as to whether various different crypto assets qualified as investment contracts, the Coinbase court looked at the various factors, including promotional materials, advertisement statements, the degree to which the issuers touted their expertise, and what benefits, if any, the issuers advertised in connection with the crypto asset ownership. In doing so, the court concluded purchasers of certain crypto assets on the Coinbase platform invested in a common enterprise and were led to expect profits solely from the efforts of others, thereby satisfying the Howey test for an investment contract. The court believes Coinbase and the instant case are remarkably similar. Again, the relevant inquiry here is whether, based on the totality of the circumstances, a reasonable investor could have expected profits stemming from defendants' efforts. The court finds it important to note this inquiry is an objective one, focusing on the promises and offers made to investors. It is not a search for the precise motivation of each individual participant. As such, the court focuses on whether an objective, reasonable person under these circumstances could have anticipated profits from defendants' efforts, rather than assesses each individual plaintiff's subjective perceptions. First, the court returns to the terms and conditions. Per the terms and conditions, by holding CryptoZoo NFTs in your crypto wallet, purchasers gain full and complete ownership of their NFTs, as well as the opportunity to utilize this NFT in minting or receiving subsequent opportunities available only to CryptoZoo holders. Oopsies. Further, under the section titled Future Projects, the terms and conditions promise, by holding a CryptoZoo NFT, purchasers will have the opportunity to participate in a variety of future opportunities. Finally, in the terms and conditions disclaimer, the issuers vow to strive to do the best for the project and the community. Next, the court looks to defendants' public statements. As mentioned, defendant Paul touted CryptoZoo, which he claimed was backed by a massive team and funded by like $1 million, dude, bro. And as so fun and a really fun game that makes you money. Later, as public confidence began to dwindle, defendant Paul assured the community he had artists working around the clock and that the project will speak for itself. Defendant Levine also chimed in to reassure the public. Let our actions speak for themselves. Defendants said that they are going to do something. They're going to do it. Tellingly, on October 11, 2021, defendant Paul said, we're coming up with really, really fun plans for 6 months, a year down the line, 2 years down the line. Like, this could be the biggest thing I do. Although the complaint does not mention the credentials of some of the members of the massive team, it does touch on defendant Ibanez's apparently inaccurate resume as it appeared on the CryptoZoo website. Yeah, we know about those. Returning to defendant Paul's volatility argument, the court is not convinced the unpredictability of the market or speculative nature of any return on investment precludes crypto sales from qualifying as investment contracts. Yeah, well, case in point, securities in the normal securities market that we're most familiar with, the stock exchange, is also highly volatile. So, but that volatility does not change the fact that, you know, you can be found guilty of securities fraud violations. So why would it here? If that were the case, virtually no crypto transaction would ever qualify as investment contracts, and defendant Paul has not demonstrated CryptoZoo's market is any more volatile than the markets in any other plethora of other cases found in the crypto transaction to be investment contracts. Well, also, and it'd be hard to, you know, prove that they were particularly volatile when you didn't, you know, do much to complete it, but, you know, that's neither here nor there. Even assuming market volatility did play a role in plaintiff's profits, and the court does not doubt that it did, the fact alone would not be determinative. Granted, Howie's language is somewhat misleading, as it requires an investor to be led to expect profits solely from the efforts of the promoter. However, since Howie, courts interpreting this language have adopted a much more flexible approach. In fact, the Fifth Circuit endorsed one such approach. We adopt a more realistic test, whether the efforts made by those other than the investor are undeniably significant ones, those essential managerial efforts which affect the failure or success of the enterprise. As such, a reasonable investor under these circumstances certainly could have been led to believe the value of his investment hinged at least on part on the defendant's continued efforts. Yeah. In sum, the undersigned is of the opinion plaintiffs have significantly alleged, at least at this procedural stage, the transactions at issue qualify as investment contracts and therefore securities. Whether, though, through later discovery, it comes to light that they do not in fact qualify as securities is not the issue of basis here. Based solely on the pleadings, plaintiffs have met their burden. Thus, the CryptoZoo transactions at issue, if properly alleged, may amount to a Securities Exchange Act violation, or, to use the defendant's term, subject them to SEC eyeballs. That said, the court turns to the first alleged Securities Exchange Act violation. I'm surprised that they didn't go into, and maybe they will here. I mean, we still got another, 15, 16 pages to go. I mean, they may get into this whole thing about how the SEC is not putting their eyeballs on it. Because, you know, the Trust Me Bro, it was a prank bro, new SEC thing. But I get the feeling the court didn't find that availing because they're continuing down this road. Because, like, that's a decision of the SEC. Like, the whole Securities and Exchange Act thing is a, you know, you have a private right of action to certain securities violations, including these. So, like, if the SEC produces a memoranda saying we're not going to, you know, prosecute these claims as a public right of action done by the state, that's one thing, but there is still a private right of action. So the SEC's decision to not prosecute these claims is the SEC's decision. It doesn't preclude private individuals pursuing the claims. It's just the SEC saying we're not going to prosecute it. It's not necessarily dispositive that, the private individual should or shouldn't get those, isn't right in bringing a claim. It's just saying the SEC is not going to do it. Whether plaintiff states a claim for Section 10b and Rule 10b-5 violations. As mentioned, Defendant Paul's second proposed ground for dismissing plaintiff's claim is a failure to meet the pleading requirements set by the SLURA. I have a feeling that's going to be the big catch here, because so far the big problem with these claims have been properly pleading them up to this point. More specifically, Defendant Paul takes issue with the complete lack of specificity, particularly as it relates to sinister and causation requirements. Plaintiffs, however, advance a different standard, the fraud created the market, or fraud on the market doctrine. I've always heard it as the fraud on the market doctrine. I've never, when they first said fraud created the market doctrine, I was confused. I'm like, what are you talking about? But I'm glad now they've decided to be use the more common term fraud on the market, because I've never heard it said as fraud created the market, which requires only a showing of presumptive reliance, a lesser burden. Regardless of the standard, plaintiffs believe they have sufficiently pled both presumptive and specific reliance. In addition, plaintiffs argue that they are permitted to aver sinister generally, particularly based on the fact that Defendant Paul knew the game was non-functional, but nevertheless made assurances to the contrary. The court first takes up the applicable standard, then whether plaintiffs fulfilled their burden. Section 10b makes it unlawful to employ, in connection with the purchase or sale of a security registered on a national security exchange or any security not so registered, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the Commission may prescribe as necessary or appropriate. One such rule, Rule 10b-5, provides it shall be unlawful for any person to employ any device, scheme, or artifice to defraud, to make any untrue statement of material fact, or to omit to state any material fact necessary in order to make the statement made in light of the circumstances under which they were made not misleading, or to engage in any act, practice, or course of business which operates or would operate as fraud or deceit upon any person in connection with the purchase or sale of a security. The Fifth Circuit has held both the SLURA and Rule 9b speak to the pleading requirements to be applied in class action securities law cases. As mentioned in the common law fraud section, requires a plaintiff to plead with specificity. The statements can tend to be fraudulent. Identify the speaker, state when and where it was said, and the statements that were made, and explain why the statements were fraudulent. Taken together, the Fifth Circuit has made the following observations about these standards. The SLURA reinforces the particularity requirement of Rule 9b. They're requiring the plaintiffs to state not only the time, place, the identity of the speaker, and the content of the alleged misrepresentation, but also to explain why the challenged statement or omission is false or misleading. The SLURA also requires that the complaint with respect to each act or omission alleged to be false or misleading, state with particularity facts giving rise to the strong inference that the defendant acted with the required state of mind, also known as sinister. Think of it like being sinister. With these standards in mind, to prevail on a securities fraud claim under Section 10b and Rule 10b-5, plaintiffs must plead a misstatement or omission of a material fact made with sinister on which the plaintiff relied, and that proximity caused the plaintiff's injuries. Southland is especially informative in that it provides a roadmap for district courts when met with the intersection of the SLURA and group pleading. In short, they are mutually exclusive. The group pleading doctrine conflicts with the sinister requirement of the SLURA because even if a corporate officer's position supports a reasonable inference that he likely would be negligent in the alleged conduct at issue, the SLURA state of mind requirement is severe recklessness or actual knowledge. With this logical inconsistency in mind, the Fifth Circuit devised a rule. Corporate officers may not be held responsible for unattributed corporate statements solely on the basis of their titles, even if their general level of day-to-day involvement in corporate affairs is pleaded. To paraphrase, a complaint attributed of conduct to defendant or defendants does not measure up to the SLURA sinister standards. Or scienter. Why do I keep saying that? It's scienter. Blech. Regardless of that particular defendant's job title within the company. Doesn't matter if they were in charge. You've got to specifically, they said it. If it was said, like, if it was just a general corporate statement or things like that, that doesn't count. They had to say it. Given the near equivalence of the pleading requirements for plaintiffs' common law fraud claims and securities fraud claims, the court need not restate what is already said in great deal above. Yeah. Just as plaintiffs' common law fraud claims fail under Rule 9b, so does their securities fraud claims under SLURA. But plaintiffs advance a different standard, the fraud on the market doctrine. The Supreme Court originally crafted this theory because requiring proof of individualized reliance from each member of the proposed plaintiff class effectively would have prevented plaintiffs from proceeding with a class action, since individual issues then would have overwhelmed the common ones. To alleviate those concerns, courts permit plaintiffs to invoke a rebuttal presumption of reliance based on what is known as the fraud on the market theory, because the market transmits information to the investor in the processed form of a market price. We can assume that an investor relies on public misstatements whenever he buys or sells stock at a price set by the market, so long as the market is efficient. Still, plaintiffs have a burden which, even if met, can be rebutted. To invoke the basic presumption, a plaintiff must prove 1. The alleged misrepresentation was publicly known, that it was material, that the stock traded in an efficient market. That's a key one that people keep running into. And 4, that the plaintiff traded the stock between the time and the misrepresentation was made and when the truth was revealed. Remember, kids, for fraud, holding a stock is not enough. You must have traded it, bought or sold, within the window of the misstatement. Like holding the stock during the period of the manipulation, like you have to have realized losses, or you paid at a inflated price because of the misstatement. It can't be, oh, the paper value of my stock went up or down. No. It has to be some sort of like physical purchasing or selling going on for this to count. Turning to the case at bar. Plaintiffs have provided no basis to support the court's application of this lesser standard. Immateriality of certain misrepresentations aside, plaintiffs' complaint and response are devoid of facts to support any of the fraud on the market prerequisite elements. Plaintiff, in essence, slaps 4 words on the page, fraud on the market, and calls it a day. Ooh, that's kind of... Court was not kind with that statement, as it had been in previous paragraphs. Or the previous, 60 pages? This will not do. Thus, the court has no choice but to defer to the slurry standard, which plaintiffs failed to satisfy. Accordingly, the court recommends defendant Paul's motion be granted, and plaintiff's Section 10B and 10B5 claims be dismissed. Not because the court is convinced the CryptoZoo transactions are exempt from the regulations of the Securities Exchange Act, but because the claims fall short of both the slower pleading standard and the fraud on the market doctrine. Nevertheless, as with plaintiffs' common law fraud claims, the court recommends plaintiffs be afforded leave to amend the claim, which has been the whole thing so far. Didn't make it. Try again, please. Didn't get there. Try again, please. Count 25. Violation of the Securities Exchange Act, Section 20A. Well, this one could be promising. Is this where we're going to get into the trust me, bro? It was just a prank, bro stuff? Here we go. Section 20A provides every person who directly or indirectly controls any person liable under any provision of this chapter or any rule or regulation thereunder shall also be liable jointly and severably with and to the same extent as such controlled persons. To establish a prima facie case of control person liability pursuant to Section 20A, a person must sufficiently allege a primary violation by the controlled persons, control the primary violator by the defendant, and that the defendant was in some way, some meaningful sense, a culpable participant in the controlled person's fraud. Further, a plaintiff must demonstrate primary liability under Section, under Section 10B prior to making a control person liability claim. We already know the 10B claims failed. I don't think we need to spend too much longer on this. Yeah, first and foremost, they failed on 10B, so you don't get 20A. Oh, they threw in RICO charges. I didn't realize this. Well, I don't think we need to spend too much time on that because, as we discussed earlier, much like conspiracy charges, RICO racketeering charges require a charge to attach to. You can't conspire to do nothing. There has to be something you're conspiring to do. And since everything else up to this point has failed, then the RICO charges fail because you can't conspire to do nothing. Yeah, because here we are. Defendant Paul may be the majority owner of CryptoZoo, but he is not the sole owner. To summarize, plaintiff's RICO claims is deficient because it does not meet Rule 9b, pleading requirements, fails to properly allege predicate acts, because all the predicate acts have been dismissed, and defies logic as to the existence of an enterprise. Yeah, that's another thing people trip up on you have to have an enterprise. These defects, if occurred, could survive a motion to dismiss, but much like the rest. Again, there's a case here. And the court keeps saying that. There's a case here. You just need to plead it properly if you don't mind. For the final argument, plaintiff alternatively alleges defendant violated Section 4.0. That has to be 4.0, right? And 22A of the Commodity Exchange Act. Plaintiffs point to 4 acts to support this claim. Defendant received and misappropriated plaintiff's funds, misrepresented the development of the CryptoZoo game, failed to provide accurate information to plaintiffs about the status of the game, and misrepresented the assets invested by the founder defendants. Section 4.0 of the CEA provides it shall be unlawful for a commodity trading advisor, associated person of a community trading advisor, community pool operator, or associated person of a community pool operator by use of the mails or by means or instrumentally of interstate commerce directly or indirectly to employ any device, scheme, artifice to defraud any client or participant or protective client or pursuant to or to engage in any transaction, practice, or course of business which operates as a fraud or deceit upon any client or participant or prospective client or participant. This sounds a lot like wire fraud or mail fraud. I'm curious if they give them a private right of action to that. Section 22A provides a private right of action under the CEA. Okay. So I guess maybe it does. Plaintiff's response clarifies their CEA claims arise under the option language in the statute. Any person who violates this chapter shall be liable for actual damages resulting for one or more of the transactions referred to in subparagraphs A through D of this paragraph caused by such violation to another person who made through such person any contract of sale of any commodity for future delivery or any swap or any deposit with or paid to such person money, securities, or property in connection with any order to make such contract any swap. According to plaintiffs, CryptoZoo NFTs operated as options on a what? I feel like that's a bit of a reach. According to plaintiffs, CryptoZoo NFTs operated as options on a commodity for future delivery. Oh well, I'm seeing the court kind of agrees with me on that. The court can easily dispose of this claim because in regard to plaintiff's options argument, which they raised for the very first time in their response, courts really don't like it when you do that. The court once again does not follow plaintiff's logic. Yeah, I didn't either. Plaintiff seems to argue the uncertain and evolving nature of the CryptoZoo NFTs creates an options contract or commodity for future delivery. In other words, because purchasers buy CryptoZoo NFTs unaware of their value until they hatch, and because the CryptoZoo NFT animals can be bred with others to create hybrid NFTs, an option contract is thereby formed. Oh, the court really did not like this one. The mental gymnastics required to come to this conclusion are truly dizzying. A futures contract does not involve a sale of the commodity at all. It involves the sale of the contract. A futures contract, roughly speaking, is a fungible promise to buy or sell a particular commodity at a fixed date. Thus, a condition precedent is the plaintiff purchased or sold a contract for future delivery. Plaintiff does not explain, nor can the court understand, how their purchase of CryptoZoo NFTs create an options contract or a contract for future delivery. Because Burke used Coinbase to purchase Bitcoin Cash rather than to make a contract to purchase Bitcoin Cash at a specific date in the future, he cannot maintain the claim under the CEA. Yeah. Seems pretty similar to this. Accordingly, the court recommends defendant's motion be granted as to this claim. And the claim is dismissed with prejudice. Well, that's the first one that's been dismissed with prejudice. And I agree. I don't know how you could make a claim out of that. So that's the only one so far that's been dismissed with prejudice, though. Which is good news for the plaintiffs on this because the court has been particularly forgiving with their nebulous, unfinished arguments is basically what it seems like is boiled down to. Notice of supplemental authority. The court finds it prudent to note defendant Paul filed a notice of filing supplemental authorities. Oh, good. I was wondering when we were going to get to this. Yes, I do want to know what the court feels about this. Please do tell. Are we allowing trust me bro arguments? The court finds it prudent to note the defendant Paul filed a notice of filing supplemental authority on April 3rd, 2025. The filing contained a staff statement published by the SEC. Although the parties did not brief the court on the procedural implications of defendant Paul's filing, the court declines to consider the notice for reasons outlined below. Although defendant Paul labels his filing a notice of filing supplemental authority, this is a misnomer. Filing of notices of supplemental authorities that come to a party's attention after briefing as a well-established practice. Moreover, such practice is helpful to the court, which of course always endeavors to apply current authority in resolving the issues before it. To the court's knowledge, this practice is reserved for filing particularly relevant cases and legal authorities that arise after the close of brief and which may assist the court in disposition of the motion before it. Defendant Paul's attachment is not a legal authority, but rather an article published by the SEC. He seems to attach the article to support his presumption that CryptoZoo's products are not a security under the Security Exchange Act, because it seeks to amplify his existing SEA argument. The attempt is more aptly characterized as a notice for supplemental pleadings, not a notice of supplemental authority. Setting aside defendant Paul's failures to move to file his supplemental pleading, such pleading is generally treated as if they had been included in the original pleading. But even if defendant Paul had, or could have, attached the article to his motion, the court would not consider it. Oof. I'm thinking for the same reasons I wouldn't have if I was, a judge. When considering a motion to dismiss under Rule 12b-6, the court review is limited to the complaint. Any documents attached to the complaint, any documents attached to the motion to dismiss that are central to the claims and referenced by the complaint, and matters subject to judicial notice under Federal Rules of Evidence 201. There exist two avenues by which the court may look outside of the pleadings at the motion to dismiss stage. If the attachment is both referenced in the complaint and central to the plaintiff's claims, or two, if the attachment is subject to judicial notice under Federal Rules of Evidence 201. Distinguishing between the two avenues of consideration, Rule 201 allows courts to judiciously notice a fact that is not subject to reasonable dispute because it, 1, is generally known within the trial court's territorial jurisdiction, 2, can be accurately and readily determined from sources whose accuracy cannot be reasonably questioned. Courts are permitted to take judicial notice of the undisputed and publicly available information displayed on government websites. Here, the complaint makes no mention of the article, so the first avenue is unavailable. That leaves the second avenue whereby the court can take judicial notice of the document pursuant to Rules of Evidence 201. Defendant Paul does not demonstrate how the SEC article is readily determinate from sources whose accuracy cannot be reasonably questioned, and because defendant Paul simply filed the article with no explanation as to the propriety of its inclusion, there's no way for the court to determine if it is undisputed or if it even applies to the crypto assets at issue in the case. Thus, there's no avenue by which the court can consider the article. For these reasons, defendant Paul's misclassification of the article as authority, his failure to move to file the article, and because the article does not fall under any recognized method of inclusion under the Federal Rules of Civil Procedure or Evidence, the court does not factor this article into the analysis. Well, darn it! Why couldn't you have filed it properly? I kind of wanted to know what the court thought about it. I'll be honest. I'll be perfectly honest. I don't think the court, again, as I said earlier, this is the SEC's decision not to do this. It doesn't preclude a private right of action. It's just saying the SEC is going to play trust me, bro, with these crypto hustlers. As damning as that might be as to the SEC's efficacy under the Trump administration, that doesn't mean that it doesn't preclude a private right of action. At least the way I see it. Leave to amend. In their response, plaintiff requests the court give them leave to amend any counts the court may find deficient. Having found all of plaintiff's claims deficient, the court considers this request. Federal Rules of Civil Procedure 15 instructs the court to freely give leave when justice so requires. District courts consider several factors in determining whether to grant a leave to amend. We kind of know already where this is going because they've given leave to amend to all of the counts except for one. Here, there's no evidence of undue delay or bad faith. Plaintiffs have had one opportunity to cure deficiencies, but plaintiffs' amended complaint added 21 new causes of action and 139 new plaintiffs, raising the new issues plaintiffs have not yet had occasion to cure. The case was filed on February 2nd, 2023, and the court does not doubt defendant Paul has expended substantial time and resources to his defense. But this alone does not warrant denial of leave. In fact, the most telling factor, futility, weighs heavily in favor of granting plaintiffs leave to amend. Many of plaintiffs' claims are rooted in some form of fraud, and as the court previously noted, plaintiffs' fraud claims, if properly pled with more specificity, could survive a motion to dismiss. The court believes this to be the case as to the majority of plaintiffs' claims. However, no matter how artfully pled or supplemented with facts, one count, this CEA violation cannot survive. Accordingly, the court recommends plaintiff be granted leave to amend their complaint to all counts save for count 27. Yep. And that's all she wrote on that. So yeah, that's pretty much it. We've been going at this for almost 3 hours now, so I don't think I'll deal with some of these other cases that I wanted to. We'll just handle them Saturday, and if I wanted to go into more depth, then I'll do another live stream like this. Heck, I will briefly say that as to the Coffeezilla stuff, he's still going to keep going forward as far as that is concerned, as far as the motion to move it over to the same court as the CryptoZoo case, because they've still got leave to amend. The case hasn't been completely disposed of, so we'll still hear that. Be interesting if you get someone to go down there and actually set in on the hearing. There's still the discovery disputes that are going on. I hope we'll get to that Saturday, but there's other stuff. This Saturday show is going to be just kind of, again, another legal episode of just more legal stuff, because of course, you got Bill Pulte and Fannie Mae being sued for its firing of a bunch of people. They filed federal discrimination claims, and now they're filing state level defamation claims, and all sorts of stuff. You've got Justin Sun suing Bloomberg and all sorts of different things going on, and then your normal stock market stuff, meme stocks and things like that we're going to go over, and things like that. So plenty of stuff to talk about, but for now, I'll see you guys tomorrow evening. We'll have our normal show, and I think I'll wrap it up here with that. Thanks for tuning in, and we will catch you next time with the whole big group.